with the assets in the bucket you want. Do whatever you want. It's yours. You get the income, you get the principal, you can wheel and deal, buy and sell and exchange, repair, give it to some guy walking down the street, burn for the insurance money. Whatever you want to do, it's yours. Do whatever you want. And then the instructions that go on to say what happens with these assets in the bucket during your life, after your death. Who gets what? Who gets what, when they get it, how they get it. And that's it. And these instructions say who carries out the terms of these inheritance instructions after your death. Because during your lifetime, you are the manager of the assets in the bucket. That's what the instructions say. You manage them. And it says, after you die, there's going to be someone who succeeds you as manager. And that successor manager, that after-death agent, has one function, is to look at the inheritance instructions and say, oh, this goes here, this goes here, this goes here, and they distribute. That's an oversimplification, but that's what the living trust is. It's a bucket of assets that comes along with a set of instructions that operates to give you full powers over those assets during your life and to transfer them after you die. That's it. There's no courts, there's no judges, no executors, no court costs, no filing fees, nothing. It's a private arrangement. Private. That's all it is. That's all it is. And it's got all this legal gobbledygook in there. And my job is to put in the right legal gobbledygook. So it depends on what your terms and what your circumstances are, who you want to leave things to. And I'm going to ask you a whole bunch of questions about your kids. I want to know everything about your kids. What do you think of them? How do you trust them? Are they good? Are they financially stable? Are they financially immature? Are they drug addicts? Are they the first people? Are they going to take their inheritance and transfer them to some crazy cult after you're gone? You know, are they the kind that are going to be subject to the pressures of their spouses to part with their shares of the inheritance so they can give it to their spouses and then their spouses walk away with it in a divorce? You know, what kind of kids are they? Do they have medical problems? Are they professionals? Do they have any malpractice problems? Because these are the kinds of questions that I need to know in order to put together the right inheritance plan for you and for the client. Yes?
So why is a living trust better than a will?
The living trust, if you remember that commercial, use a gun, go to jail? This is if you use a will, go to probate. If you use a will, you are saying that you want those inheritance instructions carried out by the probate judge. And to get a judge to do anything, you just can't flag down a judge on his lunch hour while walking down the hallway and say, hey, sign here. Sign the deed to this property, transferring it to us, the live heir. To get a judge to do anything, you've got to bring a lawsuit. So probate is a lawsuit that your kids bring after you die in order to get the judge to sign the title transferring instruments. That's what the judge does. But how long does it take to do that? It takes 6 months minimum. 6 months minimum if there's no problems. And the cost is, in California, the cost of that process, the fees that go to the lawyer, is about 6% of the assets going through probate. My dad said, I love probate. I love these probates. It's a lot of money for not a lot of work. He used to call it the lawyer's retirement fund. So, in fact, I have a chapter in the book called, probate or the lawyer's retirement fund. So, that's why. So, living trust, you avoid that probate process. Yeah.
So it sounds like you're saying that the person in charge of the trust would actually be the judge in a sense. The distributor of the.
That is correct. You are appointing someone to act as your agent after your death to do what the probate judge does, which is to transfer the assets from dead you, meaning in the bucket, to live beneficiaries.
And their word is the final word?
That is correct. The thing is this, and this is one of the subjects I actually do get to some substantive points, but when you make this arrangement of your living trust, and in this document, in the instructions, you say who are the ones who are going to carry out these instructions, your after-death agent, the after-death trustees, if I'm being technical. Are these people that you trust to do the job that they're supposed to do? To carry out faithfully your inheritance instructions. It's not a living trust. You got to trust these people. And you got to ask yourself, well, who should I appoint as the ones that carry out the instructions? Well, typically it's going to be you're going to appoint your kids. That makes the most sense because your kids are the ones who are going to inherit anyway. So appoint your kids to be the ones to carry out your inheritance instructions. And so on the way home from your funeral, your kids will come by the office because they haven't seen each other in years. And they said, well, let's drop by Condon's office to see what happened. So if they come to my office, I will see the living trust, see that they're all appointed as the after-death trustees. And I will have my secretary prepare a deed which transfers the property from the trust to them. So they're all in town, and all they do is sign this deed, and the deed says, all three kids as trustees of the client trust hereby grants to all three kids in equal shares. That was 20 minutes and $750, as opposed to 6 months and thousands of dollars. Okay, so that's what they do. That's what they do. But we have seen a wave of situations where the people who were supposed to carry out the instructions didn't do it faithfully and instead decided to do it their own way. There is a legal obligation for the after-death trustees to carry out the instructions as set forth in the instructions. But legal means nothing to a lot of folks. So we've seen a number of situations. For example, the simple ones are number of situations like this where you have your living trust and you leave $100,000 to your church or your synagogue or to your favorite charity. And your kids come in to the office and they say, I remind them, I say, okay, as soon as you coalesce and inventory all the assets, don't forget you have to write the check to that charity. Well, Mr. Condon, do we have to? Well, yes, this is not an advisory thing. This is mandatory. These are your parents' inheritance instructions. This is the words from beyond the grave. You got to do it. Oh, okay, thank you. And they go away. Because they don't come back because now I know too much. And and as far as I know, they are planning on skipping. And because how's the charity going to know? How is the synagogue going to know that they've been named as a beneficiary unless they've been told? Unless they've been told. Or the situation where there's a provision that the clients make where it says, I want $10,000 to go to each grandchild of mine who was living at the time of my death. And sometimes there's a lot of these grandkids. There was one time it was like about 14, 15 grandkids. 10,000 each. I was an English major. About 150,000. Yeah, it was math that drove me to law school. So the kids say, well, that's a lot of money. That's going to cut into our shares because we're getting the rest of everything. Do we have to? Yes, you have to. Okay, thank you. Grandkids aren't going to get the money. Or the situation where, and this comes up a lot, is, and this is kind of common, Grandpa says, I leave $100,000 to my grandchild at my death. But if my grandchild has not hit age 25, then that $100,000 will be held by my son as trustee for my grandchild, as the agent for my grandchild until my grandchild reaches age 25. So when he hits 25, the trustee son is supposed to dole it over. Well, I've had a number of situations where I know, because I know that the grandson hits 25, and he goes to his dad and says, I'm 25, where's the money? He says, well, I don't have it. What do you mean you don't have it? This is what I've been waiting for. And he says, well, my money, I mean, it's family money, isn't it? My money is family money. Your money is family money. Where do you think we got the money to go to Hawaii? Or where do you think the money came to get your braces? Or where do you think that we got the money to buy that house or pay this down? And he says, it's all good, son. We're not talking about Dad being a thief. But he was taking the position that all the money was globally for the family. But that's not what Grandpa wanted. He wanted to help his grandson get a leg up in life at the time he needed that leg up, such as for college, or as starting that business, buying that home, starting that family. So it hasn't been carried out. And there's just a number of other. I used to go on and on and on and on. In fact, when the first book came out, in '95, we did a revised edition in 2001 just for